Welcome to Ask a Lawyer with the attorneys at Karen and Ulmer PC. Today, it's Russell Manning. He focuses on the intricacies of family law. Join us as Attorney Manning answers your questions about the law and how it affects you.
Russell, what is discovery in a divorce proceeding?
Well, Steve, discovery is the process by which a attorney learns the important information of the marital estate from for the other party, things like financial information, and it's usually done through a couple of different mediums. One is written interrogatories, which are questions asking information of the opposing party, like what is their income, what bank accounts do they have, what retirement plans do they have, and that kind of stuff. And another medium would be through a request for production of documents, which is where we request that they produce copies of their statements for everything like I just mentioned.
Okay, so essentially what you're doing is you're gathering all the information and documents then you need with discovery. Am I correct in that understanding?
Exactly. It's so that we're gathering all the documents and information that we need in order to determine what the marital estate would be in order to come up with the appropriate way to divide it between the divorcing parties.
And I would suppose that the time that it would take for a client to get all that together is dependent on how much stuff they got, how much they have to get together. With that, is that a safe statement?
Absolutely. I've had clients where all they have is an IRA, so it doesn't take long to get the information. I've had other clients where there's multiple retirement vehicles, multiple bank accounts, multiple properties. It all depends on how big the marital estate is to determine for how long it takes to get the information back, and also how willing the other side is in being helpful. If somebody wants to be cooperative and get everything done as quickly as possible, then we can get the information rather quickly. If they're angry and want to drag it out, they can take as long as they want, and then we'd have to resort to judicial remedies such as filing motions to compel and motions for sanction.
So the answer to the cost, I suppose, it's going to be it depends, huh?
No, absolutely. Almost every consultation I've ever had, one of the questions they always ask is, how much is this going to cost me? And unfortunately, I have to say I really can't answer that question. It's one of the worst answers I feel I have to give, but unfortunately, because you don't know what's going to be involved until you get involved, you really can't tell them how much it's going to cost.
Is there a retainer involved?
Sure. The retainer varies depending on what it is you're looking to do. If we're talking about a divorce, our firm usually sets a retainer of $5,000 to pay up front for a divorce. And for those of your listeners who may not be aware of how a retainer works, basically what you do is you pay the money to the firm up front. We hold it aside under your name, and then as we do work, we bill you and pay ourselves out of the retainer.
Okay,
so
yeah.
You'd end up getting your first month's bill. They'd end up getting their first month's bill, and it would show that it had already been paid.
Yeah, that makes sense. Okay, so do couples have to litigate? Can they go to mediation?
If you're talking about official mediation, this is where you go to an attorney who is an official mediator or certified mediator. This is an attorney who has a lot of experience in family law, has gone through some coursework, and been officially certified as a mediator. When you do that, basically the parties sit down and meet with this attorney. The attorney gets all the information from them and then works out a deal with them all the same while they're sitting there. And then there's usually one flat fee that both parties contribute to. Then there's also like mediating, where you're negotiating with one another. Even though both parties have their own attorneys, you can always negotiate and come to an agreement without ever having to go to court. So, for example, I've had cases in the past where we filed the divorce complaint, and then we came to an agreement on how to split up the marital estate. So we drafted a property settlement agreement with all the parties signed, and then was filed with the court. They had children. We were able to come to an agreement on how to handle custody. So a custody agreement was written up and signed by all the parties and filed with the court, and they never ever went to court throughout the entire process of their divorce. And then there's litigation, which is basically you can't come to any agreements, so you go to the court, and each side puts their argument in front of whoever's hearing the case, and then there's a decision made by the court.
Okay. Now, the divorce agreement, let's say in its simplest form, couple splits up, they don't have kids, the divorce goes smoothly. It's not contentious at all. But it's still important to have a good divorce agreement, right?
Absolutely. A good divorce agreement will be one that doesn't create any potential issues in the future or create any potential confusion over future issues, and will basically answer any possible, I shouldn't say any possible question, because you can't really answer every question, but it'll set up a framework in which anything, issues in the future can be resolved within the property settlement agreement, so that there's no need to go back to court.
This is good information, Russell. Is there anything else we should know?
Well, that's such a loaded question, because the answer is probably yes. But I just, until the issue comes up, I don't know how to answer that.
Yeah, it's kind of like asking how long is a piece of string, isn't it?
Exactly. I mean, there's always going to be an issue with divorce, if somebody's divorced, because something's going to come up that you're going to be like, okay, that's interesting. How do we handle that? Usually divorces follow the same pattern and the same process, because it's a process. But every once in a while, you get that issue that's thrown in, and you're like, whoa, okay, that's new. And you got to figure out how to handle it and what information is needed to be able to handle it.
The key is being a good listener in addition to a good attorney.
I agree with that wholeheartedly, particularly because it's a very stressful process. People are going through a divorce. They're looking at an immense change in their life, and they're sometimes like, oh my God, I can't believe this is happening to me. And you need to be able to help them through it. I always say that part of my job is to lessen my clients' stress levels and to basically help them through what is probably going to be one of the most difficult processes that they've ever gone through in their lives.
Thanks for listening to Ask a Lawyer with the attorneys at Karen and Ulmer PC.